Why did Luigi Mangione's defense team suddenly drop their own high-security legal strategy? In just 24 hours, his lawyers made a shocking reversal. One day after the judge revealed their plan to use a mental health defense called extreme emotional disturbance, they filed a one-sentence notice, taking it off the table. Why? Because keeping that defense could have forced them to give his private mental health records to New York prosecutors. So did they just lose a major defense, or are they preparing a new trial strategy? Let's break down the legal moves. If you want to stay updated on the raw facts of this trial, hit subscribe to U.S. Crime Cases. We break down the real evidence. Right. Now, before we get deep into the legal paperwork and the courtroom chess match, we really need to pause and look at the human reality of this case. At the very center of all these procedural filings is a profound tragedy. We are talking about the fatal shooting of Brian Thompson, the CEO of United Healthcare, in December 2024. According to police reports, it happened early in the morning, right outside a Midtown Manhattan hotel. Think about that for a second. A man, a father, a husband, an executive who was just going about his morning routine to attend a conference. And in a matter of moments, his life was abruptly taken. I see a lot of people online getting caught up in the corporate angle or the internet drama, but we have to remember the gravity of what was actually lost that day. A family was completely fractured right before the holidays. The pain his loved ones are going through is real, and every time there is a new court hearing, all of that trauma is brought right back to the surface. We have to keep the victims centered here because the justice system is ultimately trying to address the loss of a human life. According to unsealed New York State court dockets, this sudden procedural chain reaction really kicked off on Wednesday, June 17, 2026. On that day, New York Supreme Court Justice Gregory Caro made a highly significant ruling inside his Manhattan courtroom. You see, the judge decided to unseal the official files and transcripts from a classified closed-door hearing that had taken place weeks earlier, back on June 3rd. Now, a closed-door hearing basically means the public and the press are cleared out of the room. It is just the judge, the lawyers, and the court reporter. Court records show that the defense had been fighting to keep these discussions private. But when Justice Caro ruled to unseal those transcripts, he pulled back the curtain. When those documents hit the public docket, they exposed a major legal move that the defense had been quietly preparing. The documents showed that Luigi Mangione's defense team had filed a formal notice under state law. They were officially indicating their intent to present expert psychiatric evidence to the jury during the upcoming trial. Wow. This disclosure immediately changed the entire framework of the case. Court records show that the defense was setting up a highly specific state-level mental health argument known as an extreme emotional disturbance defense. Let's talk casually about what that actually means because I see a lot of confusion out there. This is not a standard insanity plea. An extreme emotional disturbance defense does not claim that the person didn't know right from wrong. According to New York law, this specific defense actually requires the legal team to admit that the defendant committed the physical act. Yes, they would be conceding that the shooting happened by his hand. But the argument claims that the person was experiencing such a profound psychological break or trauma at the exact moment of the offense that their culpability should be reduced. The public release of these files immediately forced the defense team into a very tight corner. According to court transcripts, prosecutors from the Manhattan District Attorney's Office did not waste a single second. They immediately demanded full access to the underlying medical data that supported this psychological strategy. You can imagine the tension in that courtroom. The prosecution argued in open court that the defense had been withholding crucial details and actively blocking the state from preparing its counter-arguments. The prosecution's stance was essentially, if you're going to claim a mental health defense, you have to show us the medical proof right now. They wanted the names of the doctors, the psychiatric logs, and the evaluation notes. According to the court transcripts, Justice Caro agreed with the state. The judge made it very clear, stating on the record, "I'm not going to let you surprise the people on the eve of trial." The court was drawing a hard line. If the defense wanted to use this mental health angle, they had an absolute deadline to open their books to the prosecution. Faced with this intense pressure and a ticking clock, the defense team executed a complete about-face less than 24 hours later. Right, just one day. On Thursday, June 18th, 2026, the defense attorney, Karen Friedman Agnifilo, delivered a sharp one-sentence letter directly to Justice Caro and the prosecution team. The official court filing stated verbatim, "The defense respectfully withdraws CPL 250.10 notice at this time." That was it. Just one sentence. But that single sentence completely canceled their previous psychiatric notice and pulled the mental health defense entirely off the court record. To truly understand why this sudden reversal occurred and why the defense felt so cornered, it is incredibly necessary to look at the massive amount of physical and circumstantial evidence that police and prosecutors have compiled since the initial incident. This isn't just about legal theory, it is about what the state says they can prove. After the fatal shooting of Brian Thompson in December 2024, law enforcement agencies conducted a massive 5-day nationwide manhunt. Everyone was on edge. According to police records, the break in the case came when Mangione was eventually recognized and detained by officers at a McDonald's restaurant in Altoona, Pennsylvania. I mean, just picture that scene. A quiet fast food restaurant in Pennsylvania suddenly becomes the focal point of a massive national homicide investigation. According to statements made by law enforcement officials during subsequent arraignments, the items found in Mangione's physical possession at the time of his arrest form the absolute baseline of the prosecution's evidence. Police said that Mangione was carrying a loaded 3D printed firearm when he was taken into custody. But it didn't stop there. Prosecutors stated in early court filings that ballistics tests conducted on that specific 3D printed weapon showed a definitive match to the shell casings recovered from the Manhattan crime scene. Furthermore, police said that Mangione was carrying multiple fraudulent identification documents, a significant amount of cash, and a handwritten notebook. That notebook is a massive piece of the puzzle here. The contents of that notebook have been a central point of discussion for both sides of the legal battle. According to official quotes read into the record by prosecutors, the handwritten passages inside the notebook express deep hostility toward the American health insurance industry. Prosecutors said the text explicitly detailed a desire to target insurance executives. The official quotes used words that described the corporate healthcare system as parasitic. The prosecution has consistently argued that these specific entries demonstrate a clear, calculated motive. They argue it shows a pre-planned intent to commit murder, not a sudden emotional break. So when the defense team initially filed their psychiatric notice, a lot of legal analysts viewed it as a direct attempt to address the heavy weight of all this physical and documentary evidence. If the prosecution has a gun that matches the ballistics and a notebook that allegedly outlines a motive, arguing that they have the wrong guy becomes incredibly difficult. That is why the extreme emotional disturbance defense seemed like their most viable play. It offered a way to explain the unexplainable without having to fight the hard physical evidence. However, the sudden withdrawal on June 18th completely stripped that option away. This fast-paced maneuvering inside the Manhattan Supreme Court has left a lot of observers trying to decipher the exact mechanics of the reversal. Why abandon your strongest narrative? By looking closely at the official court records, it becomes clear that this was not a random change of heart or a simple mistake. It was a calculated, direct response to a rigid procedural rule that threatened to expose the defense's most private investigations to the state. If they had moved forward, they would have had to hand over Mangione's deepest psychological evaluations to the very people trying to put him in prison for life. They weighed the risk of losing the mental health defense against the risk of giving the prosecution a complete roadmap of his mind, and they chose to pull the plug. It is a game of high-stakes legal strategy, played out in real time. But as we watch these lawyers debate discovery rules and statutory deadlines, we have to ground ourselves in the reality of why they are all standing in that room. A family is grieving. A man's life was violently ended. And the justice system is now grinding forward to determine exactly how and why it happened, with every single court filing shifting the balance of the upcoming trial. To fully understand why Luigi Mangione's defense team dropped this shocking move, you really have to look directly at the strict mechanics of New York criminal law. It's not just a simple choice made in a vacuum. It's a high-wire, legal tightrope walk. The entire dispute we are seeing unfold here centers on an unyielding statutory rule known as New York Criminal Procedure Law, Section 250.10. But as we dig into these complex legal statutes, I want us to take a moment and keep the Thompson family in our minds, right? It is incredibly easy to get completely lost in the legal chess match, the court filings, the deadlines, and the strategy. But for the family of Brian Thompson, this isn't some theoretical strategy game. This is their harsh reality. They are seeking justice for a beloved husband, father, and executive who was violently taken from them on a winter morning. They have to sit in that courtroom and watch as lawyers argue over whether a jury gets to hear about the defendant's mental state. That takes a tremendous, exhausting emotional toll. And we always need to remember the human heartbeat and the profound grief that sits quietly behind these public court dockets. Under this specific state statute, Section 250.10, a criminal defense team cannot simply surprise a jury with medical or psychological expert testimony in the middle of a trial. You know, you see it in Hollywood movies all the time where a surprise whiz witness suddenly bursts through the courtroom doors to save the day. But in real life, the law clearly states that if a defendant wants to introduce any expert psychiatric evidence to explain their mental state to a jury, they must give formal advance notice to both the judge and the prosecution. It's fundamentally about fairness in the courtroom. You simply cannot ambush the other side with complex medical theories at the last minute. According to the official court transcript, the trap for the defense snapped completely shut when Justice Caro firmly enforced the mandatory discovery rules tied to this statute. Once the defense filed that initial notice, they became legally obligated to participate in a reciprocal exchange of information. Wow. Justice Caro issued a strict, non-negotiable order mandating that if the defense wanted to keep their psychiatric options open for the upcoming trial, they had an absolute deadline of Thursday evening, June 18th, to hand over everything to the Manhattan District Attorney's Office. If you haven't subscribed yet, hit that button to join U.S. crime cases. We bring you real, verified facts on the cases that matter most. Now let's talk about what handing over everything actually means in a murder trial. This meant the defense was being forced to turn over all of their raw, unedited materials to the state. Court dockets show that this demand included the specific names of their hired psychiatric experts, the full written results of any mental health evaluations conducted on Mangione while he was in custody, his historical medical logs, and all raw diagnostic reports. We aren't just talking about a summary letter from a doctor. We are talking about the raw interview notes, the psychological test scores, and every single thing he said to those mental health professionals. For the defense team, this strict deadline created an immediate and massive crisis. I see. If they complied with the judge's order and handed over those boxes of files, the prosecution would instantly gain a complete, unfiltered roadmap of Mangione's psychological profile. It would essentially be allowing the state's own medical experts to dissect the raw data and prepare a systematic, calculated destruction of the defense's legal theories well before jury selection even began. So by choosing to submit that one-line withdrawal letter precisely on the day of the deadline, Mangione's lawyers blocked the state from ever getting its hands on those sensitive files. According to local criminal procedure experts who are watching this case closely, this specific move successfully shielded Mangione's private psychological assessments from the prosecution's view. The defense clearly calculated that keeping their medical data completely hidden and locked away was far more valuable to their overall case than proceeding with an expert-led psychiatric argument under the state's strict discovery conditions. But what exactly did they give up when they dropped this notice? To truly understand the magnitude of this choice, you have to look closely at how an extreme emotional disturbance defense, often called an EED, actually operates inside a New York courtroom. Under state statutes, an EED claim is what is known as an affirmative defense, right? This means it behaves completely differently from a standard, everyday, not guilty defense. When a legal team decides to use an EED framework, they are not standing before the jury arguing that the police arrested the wrong person, nor are they arguing that the state's physical evidence is weak, fabricated, or unverified. Instead, an EED defense contains a massive built-in legal concession. To successfully argue extreme emotional disturbance, the defense must fundamentally acknowledge that the physical act of the homicide actually took place and that the defendant was indeed the person who committed it. You are basically standing up in a court of law and saying, yes, he pulled the trigger. But the core of the argument relies entirely on convincing the jury that the defendant suffered a profound temporary loss of self-control due to an overwhelming psychological break or severe trauma at the exact moment of the offense. The legal incentive for taking such a massive, terrifying risk is found directly in the state's sentencing guidelines. If a defense team successfully proves an EED defense to a jury, the law mandates a significant reduction in the criminal charges. It actively forces the jury to downgrade the primary count from second-degree murder, which carries a maximum penalty of 25 years to life in prison, down to first-degree manslaughter. Under New York law, first-degree manslaughter carries a determinate sentencing range with a maximum cap of 25 years in prison. Therefore, by utilizing an EED defense, Mangione's lawyers would have been running a highly calculated mitigation strategy. They would have been conceding the shooting itself while fighting strictly to take a life sentence completely off the table. They were fighting for an end date to his potential prison time. By suddenly withdrawing the CPL 250.10 notice, the defense team completely altered their tactical positioning and threw away their strongest chance at capping his sentence through medical testimony. However, local defense attorneys analyzing the docket have noted that while pulling this notice completely bars Mangione's lawyers from calling professional medical doctors, psychiatrists, or psychologists to the witness stand, it does not completely silence the issue of his emotional state, right? Under New York case law, a defense team can technically still argue to a jury that a defendant acted under extreme distress by relying solely on secular testimony. What does secular testimony mean in this context? It means they can use the testimony of everyday people, family members, friends, or situational evidence to describe the defendant's visible behavior and environment leading up to the tragic event. The major tactical advantage of this alternative route is that it allows the defense to hint at deep emotional distress during their closing arguments without ever triggering the mandatory medical disclosure laws that Justice Caro was prepared to aggressively enforce on June 18th. But think about the reality of that alternative for a moment. If the defense decides to put family members or friends on the stand to talk about his emotional state, the Thompson family will be sitting right there in the gallery listening to every single word. They will have to listen to narratives about the defendant's distress, while they are quietly living with the ultimate, permanent distress of losing Brian forever. It is an incredibly grueling, painful process for a victim's family to endure, having to sit stoically while the defense tries to explain away the unexplainable. And from a purely legal standpoint, relying on secular testimony instead of medical experts is a massive uphill gamble. A jury might listen to a renowned, highly educated psychiatrist and believe a clinical medical diagnosis. But will they believe a friend or a relative who just says he was acting a little strangely? Prosecutors will absolutely cross-examine those secular witnesses relentlessly. The prosecution will likely point right back to the concrete evidence police said they found at the time of the arrest, the fake IDs, the 3D printed gun, the massive amount of cash, and that handwritten notebook. Prosecutors have clearly stated that those items show a calculated, pre-planned intent to commit murder, not a sudden, uncontrollable emotional break. So, you can really see the absolute trap the defense was caught in. Justice Caro laid down the law clearly. Hand over the medical records or drop the expert defense. The defense looked at whatever was buried inside those psychiatric medical records and made the stunning decision that keeping them a secret was far more important than having a medical doctor testify on his behalf. Wow. That really tells you just how damaging they believe those raw diagnostic reports could be in the hands of the Manhattan District Attorney's Office. They essentially chose to blindfold their own medical experts just to keep the state from looking inside the files. It shifts the entire burden of the trial and leaves everyone wondering what exactly was in those psychiatric evaluations that made the defense pull the plug so quickly. A critical element that really drove this stunning legal reversal is the severe tactical friction between two entirely separate court systems. You see, Luigi Mangione isn't just facing a single trial in a New York State court. He is concurrently trapped in a dual jurisdiction legal battle. That means he is facing separate criminal indictments in both state and federal frameworks for actions tied to the exact same timeline. In the state system, the Manhattan District Attorney has indicted him on charges of second-degree murder, criminal possession of a weapon, and forgery. But simultaneously, federal prosecutors from the U.S. Department of Justice have hit him with a severe federal indictment, charging him with interstate stalking and firearms violations. This cross-court overlap created an extraordinary high-pressure problem for his defense team. It's like trying to play two different games of chess at the same time, where the rules of one game actually hurt you in the other. Now, before we get deeper into these legal mechanics, we have to keep our focus on the human reality here, right? We are talking about the life of Brian Thompson. His family is dealing with an unimaginable permanent loss, and every single one of these legal maneuvers happens in the shadow of that tragedy. When we talk about tactical friction or dual jurisdiction, it is easy to forget that at the center of it all is a person whose life was cut short, leaving behind a family who continues to seek answers and justice. It is important that we handle this discussion with the gravity and sincerity that his memory deserves. According to unsealed transcripts from that private June 3rd hearing, lead defense counsel Carol Agnifilo explicitly explained to Justice Caro that the defense team was trapped in a structural conflict between state and federal rules. Agnifilo stated clearly on the record that the defense fought fiercely to keep the state psychiatric filings under total seal. Why? Because the concept of an extreme emotional disturbance defense is completely unrecognized under federal criminal statutory criteria. Wow. The federal court system simply doesn't have a matching law that allows a defendant to easily mitigate a charge down to a lower offense based on a temporary loss of self-control. This massive difference in the law created a huge danger for the defense. If Mangione's lawyers had proceeded with the state psychiatric defense past that June 18 deadline, the consequences would have been immediate. Every single piece of mandatory medical discovery, every self-disclosing statement Mangione made to state psychologists, and every formal acknowledgement that he committed the physical act of the shooting would have been handed directly to the Manhattan District Attorney. Because there is active, ongoing cooperation between local police and federal agencies, that incriminating data would have been instantly transferred over to the federal prosecutors handling his interstate stalking case. Think about the impact of that. According to the defense's unsealed arguments, allowing those state disclosures to become public or to enter the prosecution's hands would have instantly prejudiced and dismantled Mangione's right to a clean, uncompromised defense in his federal trial. Federal prosecutors could have used his state mental health disclosures as direct evidence of intent, tracking, and physical execution of the alleged crimes. That would have completely destroyed his legal positioning in the federal system. So by executing this stunning reversal and pulling the state notice, the defense successfully forced Justice Caro to rescind his order to unseal the materials. I see. The judge noted that since the psychiatric defense was formally dropped, the original protective sealing order regarding his medical records remains fully in effect. It was a move aimed at survival, not just strategy. Despite this massive tactical shift, court records confirm that Mangione is not changing his plea to guilty. He maintains his formal plea of not guilty across every single state and federal count. Furthermore, this dramatic procedural turnaround will not cause any delays in the overarching timeline of the case. Justice Caro has kept the state court framework firmly locked in place, confirming that jury selection and the state murder trial are officially scheduled to commence on September 8th, 2026. This high-stakes chess match has completely divided the legal community into an intense, fact-driven debate regarding the future of the case. Legal commentators who support the strategic retraction argue that the defense team executed a brilliant and necessary damage control maneuver. They contend that exposing Mangione's internal medical files and psychological history to two separate prosecution teams this early in the litigation would have been a catastrophic tactical blunder. They believe that pulling the notice was the only way to preserve their leverage. Conversely, analysts who view the move as an optical disadvantage assert that announcing a highly sensitive psychiatric defense only to completely retract it 24 hours later signals a lack of a cohesive, unified strategy. They argue that this quick reversal creates an official narrative of confusion and desperation that could alienate potential jurors who are tracking the public docket updates leading up to September. To drive analysis on how these structural laws intersect, observers are focusing heavily on the procedural reality of the case. Think about the mechanics of the system and consider these points for discussion. Under New York Criminal Procedure Law, Section 250.10, a defense team must turn over all private psychiatric files to the prosecution if they choose to present a mental health defense to a jury. Do you believe it is fair for the state to require full medical disclosure before the trial begins, or does this statutory rule place an unfair burden on a defendant trying to establish a psychological defense? Because an extreme emotional disturbance defense requires the defense team to acknowledge the physical act of the crime took place, dropping the notice preserves the defendant's right to contest identity or other evidentiary elements at trial. From a strategic standpoint, should a defense team prioritize contesting the physical evidence over presenting an expert medical defense? The defense unsealed transcripts reveal that because extreme emotional disturbance is not legally recognized under federal law, any state medical disclosures would immediately prejudice the defendant's active federal case. In a dual jurisdiction system, should state courts offer specialized protections for a defendant facing concurrent federal charges, or must state disclosure laws apply uniformly regardless of federal indictments? These questions get to the heart of what's happening right now in Manhattan. It is a complex, often frustrating process, but it is how the system works to ensure that rights are balanced, even when the stakes are at their absolute highest. Thank you for staying with us until the end of this deep dive. Your support helps U.S. crime cases continue bringing you the real, verified truth.